Good morning, good morning, good morning. It is Friday. We got opening statements, a Richardson hearing. The bells of malevolence are ringing. We have Pop-Tarts for everyone. Not you, Boone. You don't get Pop-Tarts. How's everybody doing this morning? Welcome, welcome, welcome. The day has arrived. Everybody get their swords of injustice out, bells of malevolence, all the things. It's finally here. I hope everybody's having a good morning. I'm so glad to see everybody here. Oh, thank you, Michelle. I appreciate that. I'm glad you guys liked the intro, and I'm glad you guys liked the trailer. I appreciate that very, very much. I do have fun making them. They're a little, sometimes the process takes a little while, but I do like making them. It's fun. It's a good creative outlet for me. It helps me. Anyway, so um I did happen to listen to I didn't listen to like the actual questions that were being asked during voir dire. However, I did catch the putting together of the panel, okay, yesterday. And the part that I caught, because I got off of here late and I knew I was going to have to get up early, and I said to myself, self, you got to put it to bed, old lady. You cannot, you just don't recover like you used to, okay? Like, slow your roll, ma'am. Remember your age. You need that beauty sleep. So I did catch a little bit of the back and forth between the state and the defense during the putting together of the jury panel. And let me tell you what had happened, okay? So as they're moving through each juror, okay, each side gets 10 just objections. They don't even have to give cause. It's just, we don't want them. We don't want this person. They can strike them for any reason and no reason. It's just what it is, okay? So the judge is going through the panel of jury members, calling each number, yada yada yada, right? Whatever. And it was moving, at a pretty good pace. Things were going all right. What the judge wanted was 6 jurors, 4 alternates, okay? So the minute the words, "We have a panel," left the judge's mouth, here comes the defense. Your Honor, we'd like to strike juror number blah, 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 whatever, so over and over and over. So they actually, I think it was 3 times. And mind you guys, this was what I watched right before I went to bed. So just the numbers might be a little off or whatever, but it is the overall meaning and point of the story is there. That happened about 3 times where they had a panel. And as soon as the L in panel left the judge's mouth, the state or the defense was like, "Oh, we decided we wanted to strike juror number whatever." And that, like I said, that happened like 3 times. And then finally there was a panel, okay? And then they went on to choose the alternates. And pretty much the same thing happened a couple of times, but at the end of the day, we're now here. We have a panel. We have alternates. We're going to get to opening statements. We must first get through this Richardson hearing. Now, what I understand a Richardson hearing to be is, and again, I must preface this by saying I am not an attorney. I've never worked in any capacity in any way, shape, or form in the legal field at all, not legal adjacent, nothing. Okay. I think the closest I've gotten to anything pertaining to the legal field is I have retained an attorney at a time in my life, and I have been a passenger in a police cruiser. Whether I was in the front seat or the back seat, I'll leave to you good people to guess. The mystery that is me. Actually, the truth is, it was both. Once I was in the front and once I was in the back. It was a long time ago, many, 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 many moons ago. Wasn't even in the 2000s. It was back in the 90s. So there's that. Youth gone wild, as it were. Anywho, I believe what a Richardson hearing has to do with discovery and the lateness of discovery on the part of one party or the other. In this case, as I understand it, the defense gave over a bunch of reciprocal discovery very late in the game. And that's what this Richardson hearing is. Let me get over to the YouTubes because we don't want to miss one second of anything that's happening in that courtroom with Sarah. Let's see. Let's go over here. Okay. Court has not started yet. This morning, let me just check something to see if, let me go over here to just type it in. Yeah. Oops. If you are looking for the live stream on for Leilani Simon's trial, Deets in the Streets is going to stream that trial this morning. I confess I need a little break from streaming Leilani's trial. It has really affected me. I knew that the trial was a heavy trial. Okay. I knew it. Like that, it wasn't a surprise to me. It's not like I went in thinking that, it was going to be anything less than, awful. Okay. And hard and a heavy and serious matter. But I talked about this last night on Melissa Jade's channel when we did the recap, which you should also check out. Nadie asked, just a sidebar really quick before we get started, asks about Shmita and baby Shmita. Shmita and baby Shmita are doing so good. I got pictures yesterday. OMG. He is so adorable, you guys. I want to put him in my pocket and carry him around all day. He's just so sweet and so cute. Oh, he's just a precious little thing. Which probably also makes it that much more difficult. And also with this Leilani's trial, Quentin is roughly the same age as my grandbaby, Olivia Chicky Nuggy Pot Pie Esquire, as I call her. And also, he really, really reminds me of my youngest son, with dark hair and the big brown eyes and the olive skin. And he's just, it's just a lot. It's a lot for everybody. And anyway, last night during the recap on Melissa Jade's channel, which I enjoyed thoroughly doing. I love talking cases with Melissa and Alex Erickson. But there was a comment that kept a commenter in the chat. And I think most people know, I usually just let stuff go. I usually just, when I see stuff in the chat that I don't agree with, or they're actually coming for me, I usually just don't address it. I read it. It's not like I don't see it. I pay attention to the chat, but I just usually let it go. But for some reason, yesterday, went all over me and caught me very, very wrong. And it was basically them saying, that this is a serious case and we're making fun and it went all over me and I snapped from the panel, which I don't like to do. And the reason I don't like to do it is because, in my opinion, it's very difficult to have an exchange like that when you're on the panel and somebody is in the chat, because the person who's in the chat, first and foremost, there's a delay between StreamYard and YouTube of 20 seconds. And second of all, the person in the chat only has 150 characters to respond. It just feels like it's not a level playing field, and I don't like to do that. But the fact that I let myself do it tells me I need a break. I need to take a few beats and do something else for a little while. And so that's what I'm going to do. It's not that I'm not going to be watching the trial. I will, but I need to not cover it for a couple of days. I think that's best. And also, exactly, Neat Noodle, this too. You never want to get messy in someone else's house. And I don't. I don't like to do that, especially when, the way that the last thing I said to that person at the end of my little rant was, lighten the F up. And I just, it was wrong and I should have just let it go. So we're going to be doing Boone for a while. Just because I think I need to. It's time. I need a break from Leilani's trial. So anyway, we're just now waiting. It's 9:00. Hopefully this gets started on time. There's no wardrobe malfunctions for Sarah Boone. I know that, her outfit of the day seems to really not be changing. Mainly, the outfit of the day is the same outfit. It's a power suit, but but with a skirt instead of pants, and she's just changing the color of blouse. Yesterday it was a yellow. It was a pretty shade of yellow. I mean, this is not important and germane to the trial. It doesn't really make a hill of beans, but since she fussed so much about being able to wear, outfits and having, somebody come in to take her measurements, a la Mr. Owens, and then getting her hair did, and her hair du jour is leaves something to be desired. I offered her all the advice that I could have. They're not going to let her wear makeup. I told her, I've seen it many times in many different shorts, either on YouTube or in other I think what is that show on Netflix that is from inside the prison? That's where I learned about toilet talk. Whatever that show is, they also have other useful and helpful tips for everybody in jail, but particularly females, because when you're incarcerated, you do want to look your best. And so they've come up with very, very creative ways to have makeup using things that are not contraband, because in a lot of jails, actual makeup is contraband. They don't sell it in commissary. Some jails do, but a lot of jails don't. So did you know that you can use coffee grounds? You got to really, even though they're already ground, you got to really grind them even more, down to a powder. Vaseline, you mix it up. Voila, you have two for the price of one. You've got eyebrow color and mascara. Also, you can use, I learned this from Lori Vallow, and I don't care what she says. I've never seen blush or lipstick in this specific hue before, but I firmly, with every fiber of my being, believe that Lori Vallow is using hot Cheeto dust, and Vaseline for lipstick and blush. So I offered her those suggestions. The chat offered her suggestions for her hair. She's not taken any of our suggestions, you guys, which frankly, we were just trying to help. And I think it's rude. I think it's rude. We tried to help her with her hair, giving it a little bit of body. I mean, there's only so much you can do with that hair du jour. It is rather short. We tried. I even offered the national treasure that is M.K. Leon to do her hairs. Do you think I got a thank you? No. Do you think I got a, hey, thanks for the offer, but, not going to take you up on it? No. What did we get for our work and effort? A request for snacks. Not just any snacks, y'all. Not just any snacks, specific snacks. 2, not 1, 2 juice boxes, 2 bags of chips, 5, not 4, not 6, 5 mints, and either a Pop-Tart or a bag of cookies. Seems to me with that request, Sarah is still stuck on February 23rd, 2020 at day camp. Because that's what it sounds like to me. 2 juice boxes. Kidding me? And instead, Sarah got no snacks of any kind, not even bottled water, y'all. She's getting water in a cup, a clear plastic cup. I don't know where it comes from. It might be poured from a bottle into the plastic cup. Who knows? In my brain, the way I'm envisioning it, it's water flown specially in from Folsom Prison. Remember that scene in Walk the Line where they bring Johnny Cash the water from the prison, and it's got floaties in it, and it's definitely not clear. It has a hue to it. That's what I think of. Well, that's what she needs, MK. MK says he can give her a nice fade. That's what she needs. Like, it's there's no blending. It's like it's super harsh, especially in the back. So, it is she needs some blending and a fade. But yeah. Maybe she can make friends with Letitia Stout, and Letitia can teach her all about toilet talk. Letitia can pop a toilet in 10 seconds. I think Letitia should add that whenever she goes through when she's writing out her lawsuit, because she's suing El Paso County, WellPath. Now she's currently involved in suing Topeka Correctional. Maybe she can pop a toilet in 10 seconds and in her on her LinkedIn. Bless it. We have movement in the court. We're just waiting, like everybody. Michelle says, remember Adam Montgomery and the big chunk taken out of the back of his head? Someone did him wrong. Yes. Especially given the fact that if he would have attended court, or attended his trial, the jury would have only seen his face, but it was obviously streamed. And so the audience, us, and the people sitting in the gallery in person would have all seen that. Okay. This is the $11 billion question. Mel whatever says. Also, by the way, hi Mel whatever. Big Spoon. Hope you're doing well. I think of you frequently and I watch your posts and I check in on you, but I just watch from afar. I don't want to overstep. I don't want to make it weird. Asks, is she taking the stand at some point? Yes. The answer is yes. What happened is through a series of motions, okay, what the judge ruled was that the defense can mention battered spouse syndrome, okay, in their opening statements. What they cannot do is put on any evidence of battered spouse syndrome until Sarah Boone herself takes the stand and testifies to the overt act that triggered her battered spouse syndrome response. Sarah must 1,011 billion% take the stand if they intend to use the battered spouse syndrome defense. She must. That day that happens will be the day that if she starts in the morning and then they go through the afternoon and they stop at lunch, right? And they have to take lunch and then come back, I will skip nap time to stream that testimony. Because what I suspect is going to happen is I believe that Sarah is going to alter her testimony. And the reason I believe that is because back in early October, okay, Sarah was evaluated by two experts, one for the state, one for the defense. When the expert witness for the state evaluated Sarah at the Orange County Jail, the state was allowed to be there. Okay, they were allowed to witness it, and according to Mr. J, some of the things that Sarah told told the state's expert witness differed from things that she told her own expert witness during the evaluation. And so now that the defense, the ruling with regard to the battered spouse syndrome has been issued by the judge, which is that Sarah has to testify to the overt act, I believe that Sarah is going to alter her original testimony or her original statement. And technically, it's not her original statement. It's actually an altered statement that she gave during an evaluation. It's a different statement. She's changed her story, okay? Because as we all know, from the minute this happened, right, from the 911 call, then to the body cam footage from Officer Rodriguez, then to the interrogation, Sarah has steadfastly maintained that this was 111% an accident. Further, in the interrogation video at the very beginning, when they're asking her about the scratch marks and some of the bruises that were discovered during Jorge Torres's autopsy, Sarah said, and I quote, "Nobody got out of sorts that day. Nobody put their hands on anybody that day." So then when they did the motion hearing, not yesterday, but the day before, so Wednesday's motion hearing, okay, there was the state was arguing. She has yet to to say what the overt act is. And furthermore, her expert witness in deposition hasn't stated what the overt act is. So after a lot of circular arguments, Mr. Henderson, who is her second attorney, there's a third attorney also, but Mr. Henderson was the one that handled this particular argument. It was a lot of circular arguing. It was just like, it was so tedious and frustrating. Anywho, finally said that the overt act was George having his fingers starting to come out of the suitcase, which also doesn't make sense because Sarah made it a point in her interrogation video to say that was the one intentional thing she did, was to not zip up the suitcase completely, that he had two fingers that he could get out. So none of this makes any sense. I don't understand it, but I believe that Judge Kranick ruled in the way that he did because I think if he would have not allowed the defense to present battered spouse syndrome, given the caveats that he did, which is that Sarah has to get up on the stand and testify first, I think that what he was trying to avoid is an appellate issue, quite frankly. And I think in my opinion, he ruled correctly because I think what he did is he left it up to the jury. The jury in this situation, in every trial, is to be the finder of the facts. So basically what Judge Kranick said is, look, you can mention it during opening statements. You can't talk about it during your case or in any cross-examination until you put Sarah Boone on the stand and she testifies to the overt act. And I'm going to leave it in the hands of the jury. You do what you put your case on, and the jury will sort it out, which I agree with. I thought that was the right thing to do. Oh, whoops. Hold on a second. Nadie, thank you so much. Nadie generously gifted 5 memberships. If you were the lucky recipient of one of those 5 gifted memberships, please thank Nay. She's so sweet. And also, while you're thanking Nay and while we're waiting for this to get started, I would like you to head on over to this link that the Nightbot is dropping in chat currently. Nadie makes the absolute best wax melts. They all smell wonderful. They smell delicious. The scent combinations that Nay creates are out of this world. They are long lasting. They are strong in that, let's say you have only one melt burner thingy in your house, right? If you put one of Nadie's wax melts in it, you will have the scent throughout the house. They're amazing. And if you use the discount code Queen of Roasting, you will get a discount. Now, seriously, you guys have got to try. If you haven't already, you've got to try Nadie's wax melts. Aw, thank you, Nay. I appreciate that, babe. Also, and this is really cool too, because Nay said, Bendy, I'm going to send you a fall box in a week or so. When you receive your order from Nadie, they're not only are they personally packaged for you, the package itself is personalized. Great care is taken when Nadie, and you can tell she takes an amazing amount of pride in her work, and she just does a fantastic job. And quite frankly, I just adore Nay. And so please take a moment to check that out. You know, Christmas is coming. We all have, those relatives or people that we are not close to and don't know that great, that are, you kind of like, oh, like in the office party, at the office Christmas party, when there's a gift exchange and you don't really know this coworker all that well, you can't go wrong with Nadie's wax melts, even if you order a gift card and order wax melts for yourself. It's perfect. They're great stocking stuffers, all the things. I'm telling you, you will not be disappointed. So, good morning to everyone just coming in. Happy to have you here. If you guys haven't done so, please do me a favor. Give your girl a thumbs up on the stream. If you want to, give me a thumbs down. I leave it to you. It's up to your decision. Just one or the other, please. I'd appreciate it. I would prefer, obviously, a thumbs up. But hey, if you don't feel I'm doing a good job, keep me in check. You know? Like Sheree said, who gonna check me, boo? Y'all gonna check me with the thumbs down if you feel that I haven't done a good job. So, yeah. Here we go. Any moment now. Hold on a minute. Let me look at something really quick. Let me just check something out momentarily. Also, while we're on the subject of holidays and such, I have been in my time that I'm not streaming trials, I have been working diligently on a little project talking about the true story behind the movie Amityville Horror. If you would like to refresh your memory of the movie, the original 1979 release is on Max, as well as the 2005 or 2000, is it 2005 or 2009? Un momentito, let me check. Let's see. 2005 remake, which is also good, is also on Max. So, oh, Thornton, thank you so much. Oh my gosh, look at this baby in the picture. So cute. Thank you, Thornton. I appreciate that. Thank you very, very much. It's very generous. Thank you. I appreciate that. Thank you for supporting me in the channel. But yeah, that's the deal. Hold on a second. Let me see. Oh, they do. Yay for Law and Crime and their closed captions, because let me ask the chat while we're waiting. Do you all think the defense is going to utilize their microphone correctly today? A 1 in the chat if you think they will, a 2 in the chat if you think, nah, they've never utilized it correctly before. Why should today be any different? But yeah, I'm doing the true story behind Amityville Horror, and I've already done a couple of lives on it, but this will be like a combination of the first 2 lives. It's going to be redone though; it'll be different. It won't be the same. But and then the third part of which I always intended to do, but life got in the way, and then quite frankly, I've kind of forgot. And some people have reminded me. People are like, "When is part 3 going to come out?" So that should be out. I'm really hoping for a Sunday premiere. So be looking out for that. And then after I cover the Amityville Horror, the next series in the Conjuring universe that I shall be covering is the true story behind first Conjuring, the story of the Perron family. Then I'll do the Conjuring 2, which is the Edinburgh Poltergeist. That one's pretty interesting. And then the third one I will be covering is the third Conjuring movie, The Devil Made Me Do It, which is the story of Arnie Jackson and the Brookfield possession, as it's become known as. So that one is quite interesting, in my opinion, because for a couple of reasons. Because there's an actual crime involved. There's an actual murder involved, like with the Amityville one. And so I like that there's a blend of both. So yeah, that is what's on tap for Halloween. I love Halloween. Oh, 11 Summers Mill. Bless your heart. Yeah, this is an odd view, but whatever. I'm not going to complain. Listen, we're here. This has been 4 years, and now I believe July, August, September, October, 4 years and almost 8 months in the making. You know, I mean, it's been a long time. And, you know, I'm happy this day is here. Not for us so much, although you guys know, I have the best time discussing this case with you guys. You come up with really great ideas, very astute observations. I don't really care what anybody says. I have the best chat on the YouTube streets. I've said that for a long time, and I mean it. I have the best chat on these YouTube streets, along with Alex Erickson and Melissa Jade, because we share many of the same subscribers that make up this true crime community, and it feels, you know, the same. The vibe is the same when I go into Allie's chat or when I go into Melissa's chat. We have the best chat on the YouTube streets. But really, for me, you know, I've been thinking about this a lot lately. The trial, the upcoming trial, and how many times we have been close to a trial only to have something come up, like a lawyer files a motion to withdraw, which is granted, which starts the process all over again, and how frustrating it is for us. But I cannot imagine how frustrating it must be for George Torres's family. You have to wait and it be put on hold over and over and over again. Whilst in the meantime, Sarah is writing letters claiming to be the victim of everything and everyone. Oh, yikes on bikes. Well, Miss Boone has decided her outfit of the day will be a black power suit today, and she is wearing a very bright pink blouse underneath. I would have advised against pink, simply because, quite frankly, Sarah has a ruddy undertone to her skin, and I think that she should avoid any hue on the color wheel that is off of red. Pink, even a very pastel pink, I would think is not a good idea for her. I think it enhances the ruddiness. Not a good idea, but what do I know? What do I know? She's today, unlike other days that we've seen of Sarah in court, she appears to just be sitting still. Normally, she is in her seat and shuffling papers, writing the words important on all of them because everything is important to Sarah. Not sure who she's waving to, but she seems to be in good spirits. Let's see if Mr. Owens took my advice and remembered the last few letters his client has written to the judge that ended with 3 pointing back. and stops pointing in court. It's rude.
I'm ready when you are.
The code, Remy, is Queen of Roasting, babe.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table, wearing a black suit and a pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2 as identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning by way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Your Honor, most of them deal with just billings, observations by the medical personnel, so that don't necessarily apply to the issue of anxiety, as the court indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety. And then I've identified 4 or 5 other pages that are not anxiety related, or maybe relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
You speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111. It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22, 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there's a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, 2. The forensic pathologist will testify for the state, and then our expert on Battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant. The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment
Thank you.
of January 23rd, 2018 was my understanding.
Okay.
Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time. Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was
Bless you.
tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete. And
But they are also seeking 49, correct?
Yes.
Thank you.
Just they just skipped 48, just like they skipped 26.
Okay.
Page 63. It appears to be repetitive, but we don't have any particular objection. Page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018. So we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The defense did, or I'm sorry, the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 7th 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is, I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in, and it was mailed in from the hospital to my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. It was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received. And we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital. So we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may real quickly, based on the invoice that was sent from the work advance billing department, actually it's a separate subcontractor, the request was made on the 27th of September. I suspect they waited until they received confirmation of payment of $135 for receipt of those. So we received those. So it's all been within a couple of weeks, but we had a hurricane issue last week, and I think there were issues as to the matter being provided for. I did speak with the state yesterday afternoon after I had a chance to look at the records, and I did sense what the matter or relationship to, and was told that they already had those records and we were good with them. So I don't think there's any prejudice to the state based on our submission.
Okay. Any further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purpose of this hearing, I'd like this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Your Honor, there was just a reference that 31 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please. If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand? Thank you. You may proceed.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as 1, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide information.
I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand the state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge, yeah, the defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are evidence of prior threats, prior events of violence committed under that instruction. Under the self-defense, justifiable use.
Here's my concern. Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did quote up a couple of these on the justifiable use of non-deadly force.
That does not answer my question.
I would agree not to use those.
Okay.
The two I'm interested in using and opening is this standard instruction. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon instead of the verdict. You want to read it out?
No, I can see it, sir.
And then the other one is a reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt is the standard instruction.
What's your position with regard to those two, Mr. J?
Judge, opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions. We're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may in fact read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
Judge, I've been doing this 35 years. I've had these boards. I've used these boards in opening statements. I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions to eliminate, trying to prepare my opening statement, and doing all the things that I should be doing on the eve of openings. But I did notice that I did not believe the reasonable doubt instruction was complete just from memory. And I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
This is an excerpt from.
Give me a moment.
Just so you guys know, I am reading the chat and I was looking to see if I could find anything on George Torres's parents no longer being alive. I know that his mother spoke in June of 2023, but I can't find anything to either confirm or deny whether they are still living. But I'm still working on it. Meanwhile, just so you know, this
That
is
seems
what's
to be the
going
standard
on
3.9 instructions, or at least portions
currently
of it. Response?
Again, since it's
in
not
my
all of it,
house.
it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law, that in many ways, we do it where we give them the law at the very end, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
And I think for the record, we should mark them.
Okay. Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Stop pointing. You don't need to point. I don't know who the people, I'm wondering maybe if these are clerks, law clerks. I'm not sure. I've never seen this setup before. So I'm kind of curious myself as to who the people standing around the judge are. My cats remain #unimpressed by these arguments. Lisa, I think the argument about the 3.9 is it has to do with the demonstrative exhibits. Are they going to be simply demonstratives, meaning that they're not going to be entered into evidence so the jury does not take them back to the jury room for deliberations? They're not an actual exhibit. They're simply just a demonstrative. I think that's what they're talking about with 3.9 or 3.0. Not exactly sure. I'm not an attorney, and because Owens is going in and out off the mic and on the mic, it's really hard for me to sort of make heads or tails of what he's trying to do here. I just don't get it. I mean, typically, if we're going to argue jury instructions, quite frankly, the standard jury instructions before the start of opening statements is this: opening statements are not evidence. They are intended to tell the jury what each side expects the evidence will show. That's what opening statements are. So to use demonstratives that are also evidence that the defense intends to enter into evidence is a no-no. I don't. This is ridiculous. Absolutely, completely ridiculous. You know, I'm really over the argument from Owens respective to time. Either, as you know, Your Honor, I only got on this case 45 days ago, or today's argument, I've been doing this for 35 years. You know, a lot of people have done things for a number of years. That does not mean they're doing the thing that they're doing for the last 35 years correctly. Different courts have different rules and procedures of the way that they conduct trials. But overall, the governing body of criminal procedures is in the Florida criminal procedure statutes. There's that covers the entire state of Florida, the whole peninsula, the Keys, and the Barrier Islands, the whole enchilada. Okay, so I don't know. I don't get it. I really don't. I do not understand. I cannot. I'm usually pretty good at least somewhat being able to understand somebody's line of thinking. Okay, not so much defendants, only because usually they're on trial for murder, and I really just can't come around to that line of thinking. But with Mr. Owens, no matter what I do, no matter how hard I try, I cannot ever understand or see where he's coming from in his line of thinking, for Pete's sake. It's so annoying to me. Well, Crime Crochet and Coffee says, I've been rewatching the entire Betty Broderick trial, and they used very large displays like this in opening and throughout the trial, which makes sense because it was in 1991. Yes. Okay. So there are rules about using demonstratives during opening statements. And what Owens is attempting to do is use demonstratives that he actually, that are, enlarged photographs that he actually intends to admit into evidence. That's where it gets fuzzy. And especially if those demonstratives / later exhibits include jury instructions or interpretations of the law. That is a no go. It is the way in which he's attempting to do it that the state is objecting to.
Okay. Next photo.
Because there is a different standard to answer Maria. There is a different standard for demonstratives, which are simply displays, there versus actual exhibits that they intend to enter into evidence. There's a different standard of acceptance of those by the court. Okay, when it is a demonstrative, which is just exactly what it sounds like. It's just simply it's not an, it's just basically a display, I suppose is the best way to explain it. And it's not going to be used as an exhibit and entered into evidence, which is what the jury is allowed to then at the end of the trial take back to the jury room and aid them in their deliberations. There's a different standard. And some of the photographs that Mr. Owens has had enlarged, for one thing, they intend to use those also as exhibits. And so when you're talking about using something as an exhibit versus using it as a demonstrative, when you're going to enter something into evidence, a proper and correct foundation must be laid first in order for them to do that. And there is no when the defense and the state are giving opening statements are not evidence. What they are is a statement of what the state and the defense expect the evidence will prove. So he's basically trying to have it's like double dipping, and it's improper. So that's what the argument is about. And again, Owens is a procrastinator and has poor time management skills, in my opinion. And all of this stuff is done at the last minute, which makes Mr. J, the prosecutor, have to work extra hard and frequently on his own time that he's not getting paid for. And it's just bad form. And for somebody who says, I've been doing this for 35 years, you ought to know better, bruh. Okay, I'm going to stop sharing the tab just for a moment, because I'm wondering, since I downloaded that audio booster, if I have to restart the tab. So let me do that really quick while we can't hear anything anyway, and then I'll put it right back up. Okay, just give me 1 second, because I want to make sure you guys get to hear everything.
I think you were already on the bench, so you sent it to the clerk and
Has the state seen a copy of it?
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one, but I'll check.
This is just these two cases. Been provided Alsager v. State, 326 7th 3rd, 656, Florida Supreme Court, 2021. Lowe v. State, 259 7th 3rd, 23, Florida Supreme Court, 2018. Yes, sir.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alcaguer case, which is the 2021 case, Supreme Court trial court acted within its discretion in permitting state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that was in the record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound, advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. Court allowed, again, court's discretion. As you know, we're claiming self-defense, and as part of that instruction, we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is different from the norm. Take the two instructions we read. Find that Sarah Boone, who because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of George Torres, you may consider this fact in determining whether the actions of Sarah Boone are reasonable. Goes on to say, if you find at the time of the alleged second-degree murder, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact to determine whether Sarah Boone reasonably believed it was necessary for her to use violence. We have a good faith belief that the exhibits will be introduced into evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship.
But they can't be
The
both.
actions that Sarah took and the reasonableness of those actions in light of their history.
No, Kathy, we're still
Any
talking
response,
gibberish.
Yes, sir.
Yes, sir.
Judge, the standard is, it is your discretion, and you will only be reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow the parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during the opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary. Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that it's from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet from the defendant, and certainly this is A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to introduce from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate ground. And then returning back to C, D, E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I inclusive?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. It's, I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch with her dogs. But A and then C through I, judge, absolutely at the end of the trial, great. Blow them up, use them as much as you want. But in this particular case, with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in and open. Remember that? prior
No, what I
ruling?
ruled is that you were able to discuss them, address them in opening. Photographs are a totally different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. And arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
Did Judge Pranick say kitties? Here's
We believe there's
kitties.
going to be evidence of an overt act.
And they're waiting for the overt act to be explained as well, Mr. Owens. They're bored. Look what you've done to them.
Understood. Your response to Exhibit B.
Look at which one's the-
It's her on the back porch with the two dogs.
Thank you, Sharon, for becoming a member. Welcome to the ward. I appreciate your
That's not
support.
the issue.
Thank you
The
very
issue is that
much.
the state represented that it was not part of your exhibit list.
I believe it is a part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce, that they've listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, Jorge Torres, he abused the dogs. and he would threaten to abuse the dogs to control Sarah Boone.
Okay, thank you.
They're checking judge
All right.
on whether they have.
The court's prepared to rule at this point in time. Thank you both for your presentations and your argument. The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met. The court, again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we prepared to bring in our jury at this time?
Got two other issues.
They've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute suitcase video to the jury in opening statement.
State.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
What's the other issue, sir?
I need to approach the bench.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. I'm not going to allow your photographs, not going to allow the state to do anything. You can orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
Y'all, is this real life? Did Owens ask if he could play the 2-minute video in opening statements? Let me rewind that just briefly while they're up there. Hold on a second.
Witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach, I'm asking you to urge your discretion.
Jury in opening statement.
You've been waiting for an hour and 20 minutes, Counselor.
We intend to play the 2-minute suitcase video to the jury in opening statement.
He did. He said it. Y'all, this just begs the question. Bruh, what are you thinking? What do you think that video shows? You think that video helps your client in any way, shape, or form? I don't give
Any
a
reason why we cannot bring in our jury at this time? State.
No, sir.
I don't give a rat's fat kneecap what magic words you think that you have swirling around in that brain of yours that are going to make the evidence appear as something it is not. I am shocked, y'all. Shocked. This was definitely not on my bingo card. The only thing that I can think of that this would serve to do is he wants to get it out of the way. He wants to be the side that brings it up first. Holy guacamole.
Good morning. Y'all may be seated. State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Can the parties approach for a moment?
Mr. Owens, for the love of Pop Tarts, can you please turn on your microphone? It has an on off switch. If you're concerned about the microphone picking up what your client and your team are discussing, turn it off. But when you are going to address the court, could you please
All right,
turn
members
it
of our jury,
on?
good morning. I want to just confirm before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment? And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you. All right, thank you both for your honesty. I appreciate that. It's something we talked about earlier this week. That's the one thing that we required and asked of you, is just be open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way, to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. J, you may proceed, sir.
Thank you. Ladies and gentlemen, what the evidence in this case is going to show you is that this defendant zipped Jorge Torres shot in a suitcase. She was able to do this because at the time of his death, he only weighed 103 pounds. And she did this with the malicious intent to punish him. And then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes, because there's going to be 2 videos that the defendant herself took of this event. The evidence is going to show Jorge Torres is dead because in this defendant's judgment, he deserved it. Now, for conscious disregard for whether he lived or died, you will see and hear these videos. What I expect you will hear from a video that began at 11:12 p.m., 45 seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah, the defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby. That's what I feel like when you cheat on me." Sarah, "Fuck you. I can't fucking breathe, Sarah. You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103-pound Jorge Torres is put into this suitcase left to die? Well, the next morning, the defendant wakes up, late morning, perhaps early afternoon, somewhere in this time range, several hours later. And she goes downstairs, and she doesn't see George anywhere, Mrs. Torres, and eventually realizes, oh my God, he's in the suitcase. The first thing she does after taking him out, and I believe you will hear a description by the defendant saying, took his little legs out. At some point she makes that statement. And tries to resuscitate him. Here's gurgling as she presses down on his 103-pound chest, forcing whatever air was trapped in there out, gurgling. And the next thing she does is she doesn't call 911. She calls Brian Boone. Who's Brian Boone? Brian Boone is her ex-husband. They share a child in common. include Friday, Saturday, Sunday, so it's that free schedule. And then Monday through Tuesdays, their child would be her responsibility. And Wednesdays and Thursdays, their child would be Mr. Brian Boone's responsibility. So February 23rd, 2020 was a Sunday. And now we've led into Monday. Mr. Boone had been trying actually to contact the defendant several times that morning because he just wanted to confirm she was going to get their child after school that day. And there had been a history of reliability issues on that issue on her part. So you will see in the phone record, he calls her, and then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, about 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right. There's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though. Being calls her. Then she finally calls him back instead of calling 911. And being the nice co-parent that he is, he comes over. It's a short drive, about 10 minutes. And as she's explaining to him what the heck is going on, he peeks in through the front door of her townhouse, which allows you a view all the way to the back sliding glass door. You're going to see that her kitchen is off to the right, but there's a doorway that you can see all the way through. And on the back side of the kitchen in the breakfast room area, there's tables and stuff. There's also some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't set foot into that townhouse. He does wait outside though, being the good co-parent that he has been. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant makes the 911 call. What you will not hear are tears. You will not hear sorrow. You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase, and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. So she mentions that there was blood coming out of his mouth. And his body, like all bodies in suspicious deaths, was taken to the 9th District Medical Examiner's office in autopsy. What the doctor found was what you would expect after being left in the suitcase, crumpled up in the fetal position. He passed from positional asphyxiation, meaning like you're not going to get full breaths when you're crumpled up like an accordion, and environmental suffocation. You don't have to have a plastic bag over your head, tape shut with a full roll of duct tape to seal it off 100% and be worthy of the vacuum of space to environmentally suffocate. It's close enough if you can't get the oxygen and the CO2 coming in and out of your environment. did notice, yeah, he suffered from blunt force trauma on his torso, in his face, his mouth. She'll use words like contusion, will help her explain contusions and bruises. She'll use words like hematomas, will help her understand for you all that that means bleeding under the skin and blood, what you expect from a bruise, that's why they're running through. But he had all this additional trauma. He had trauma on his fingers as well. So now, the sheriff's office, Orange County Fire Rescue show up, and the defendant interacts with the first patrol officer. You will see and hear that body-worn camera. It's more of the same as what we heard on the 911 call. Hide and seek. It was good. I fell asleep. I don't know what happened. A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her and are ready to interview her after doing some initial things, which includes grabbing her cell phone off of the counter that was found at the suitcase by Mr. Torres, and giving it to one of their digital forensic examiners, who we'll hear from later in the trial. But it's time to give a first interview with the defendant. So they do a first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken. But the basics of what the defendant tells them is we had wine, we painted, we drew, we did puzzles. The particular wine we had was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were literally just enjoying one another's company. The other bottle of wine that was left over from Boone wasn't even half full. So the description she is saying is 1 bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same. Many of us may envision what you would expect at a restaurant. Those are 750s, 750 milliliters of that. Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, so the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces. Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those 2 bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are in fact Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had 1 bottle of wine and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's 2 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class. Plus, if you believe that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it, doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. 2 little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoked, did art, listened to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day ends with the police. She goes and sleeps and stays at her ex-husband's house the night of February 24th. What they are doing, and by they I mean Orange County Sheriff's Office, in part, is going through her phone. That's when they discovered the 2 videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself. Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events. At this point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought it was I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before, though she described it happening before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces and nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote unquote dad hit me in the face. The next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres, getting rid of. And that's the case. That's what the evidence is going to show. But we, the state of Florida, and the members of the jury in our journey through this case, we're all going to come up to a door that says, danger, keep out, stay away, by court order. And that door says, the defendant's history with the victim. It is a door we shall not enter without permission and invitation. Halloween in like 13 days. Part of the vampire lore is vampires can't come get you in your own house. Well, I participate during this trial. We're going to be invited in to the defendant's past relationship for the previous couple of years with Mr. Torres. And as we come inside this room, at her beckoning, we are going to have things pointed out that she would like us to focus on. And you're going to hear the first night the defendant met the decedent, Mr. Torres, he smashes her phone, punches her. It's the first time in her life she'd ever been punched, I expect the testimony will be. And he made her curl up in a fetal position on her own porch for 4 hours, and she was only able to escape this situation when he fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level was a 342 once when he got treated at the hospital. This is a man who has serious alcohol problems, and I expect going to hear about that. Despite that first date, and this is going to tie into some other things that I expect could possibly come in. Despite that first date, despite at that point in time of this first date not having a relationship, emotional ties, and the things that come along with a relationship that make it harder to break off a relationship, it's one thing to have a bad first date. It's another thing to end a 25-year marriage. Despite that first date, there's a second and a third. Now, these days are at bars, and there's nothing wrong with that. But, and it just typically ends up, she's going to tell you, I suspect, or you're going to hear that she said, one way or another. It's one thing or the other. Like, I ask a dude for a cigarette, Mr. Torres flips out, and I'm going to pay the price. Just things like that. You're going to hear and potentially see, yes, there were injuries that the defendant is going to attribute to the victim causing her. Black eyes, cuts in the face, perhaps from the curtain rod incident that was mentioned in the police interview, happened about a month before this. Bloody ear, a stab wound in the leg, which is perhaps described as sword fighting and playing around in medical evidence. But nonetheless, I suspect you're going to hear and see a lot about their past history. And at the end, if this occurs, if this comes in, the state is going to have the opportunity to take the lead of the tour in this room labeled the defendant and the victim's past history. And I'm not going to go into that now. If this all comes to fruit, the blooms on the tree during the trial, we'll discuss it at the end where it's more appropriate. But I'm asking you to not rush to judgment until you hear all of the evidence in the case. And then apply whether or not these past instances have anything to do with what happened on February 23rd. Now, like a home inspector, there are experts to come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance we may hear from some experts, psychologists and psychiatrists, about battered spouse syndrome. The state is not challenging in any way that battered spouse syndrome exists. It's well recognized, the experts will tell you all about it. Not disputing that at all. But there's some things that we would hope that you pay attention to during all the testimony, if there is any, about this subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5-ER. Diagnostic Statistical Manual, version 5. And I think it's text revision, something like that. What it is, and what they describe it as, is kind of a component of post-traumatic stress disorder, PTSD. But because it's not actually in the book, it's like a recipe book. It's like our statute books for lawyers. You go into this book and say you have a particular disorder or diagnosis. It'll say, well, all of us agree that it needs these three elements, like elements of crime. Some of these elements have to be prevalent for a certain amount of time, so on and so forth. You imagine it's a cookbook. Gives you the recipe for a diagnosis. But because it's not in the cookbook, you may get some disagreement about what it means between the experts. It's kind of like grandma's recipe handed down from generation to generation without being right. But what I expect you'll hear is, it's important for people who don't have experience in certain abusive relationships that are violent to understand the control that can be exerted over an intimate partner by the other one, isolation, psychological violence, emotional violence, physical violence, sexual violence, described for you as well by the defendant, perpetrated on her by the decedent. You will hear about all this. And what it ties into at the end of the day, after we talked about this during jury selection, is if there is a self-defense instruction read to you, this is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society, but years ago when this was first being researched, the question would be, well, why wouldn't you leave? In battered spouse syndrome, the testimony from these experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, the isolation, control, so on and so forth. And that explains why you wouldn't leave. Well, now, but turning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances taking those actions if you get a self-defense instruction requirement. That's what it's used for. It's not used for explaining the subjective beliefs that one holds. What you will also hear about these things is, just like any other doctor or any expert, a home inspector. If a home inspector's report was based solely on the person who's trying to sell the house, what they say about the house, great shape. I rewired the entire thing. Brand new JDC pipes. This sucker's good to go. I agree with this. You're not going to take that home inspector's report unless they lift the hood, kick the tires, do all the things that the Fox on here, Carfax does. You want an expert to get reliable information. An expert's opinion is only as good as the information that he or she relies on. They will say, yeah, you gotta take into account the credibility of the person who's giving you the story. Even if it's the patient, the client that is saying all these things happen to her. You gotta find proper information. You gotta check reliability. Particularly in circumstances that we discussed. So, another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two intimate partners doesn't mean that spouse syndrome applies. Some people can go home and fight like cats and dogs. And that's just their day. They get over it. They live their life to find another day. Their cycle just spins like that. So just because you hear about those things, what the experts will tell you, doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Harper will say that it applies to this group. But we'll talk to her about what she relied upon to make that conclusion. We'll talk to her about some other things and take that journey together to get there. But at the end of the day, after you hear all of the evidence in this case, particularly straight from the horse's mouth, the video, where you don't have to rely upon the credibility of anything other than your own two eyes, your own two ears, the state admits that you're going to return a guilty verdict for second-degree murder. What the evidence is going to show is that the defendant killed Mr. Torres because she decided he deserved it. Not because the evidence will show an objective, reasonable person in her circumstances needed. Thank you.
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you. You may proceed, sir.
Ladies and gentlemen, good morning. Appreciate y'all being here. I was introduced before. My name is James Owens, and I represent Sarah Boone, along with Tony Henderson and Kevin Beck. Now, this is going to be a several-day trial. Obviously, today, Tuesday, Wednesday, we're not sure, but we're trying to make arrangements for witnesses to fly in know your focus is on this case because you took it. Ladies and gentlemen, there is no higher calling than to right on. No higher calling than to right on. And we're going to ask you again to right this wrong. And find Sarah Boone not guilty because she was justified in the force that she used to defend herself. That force was reasonable under the circumstances that existed between Sarah Boone and George Torres. Sarah Boone and George Torres were down and out, as you can be. Their life centered around alcohol. Both of them suffered from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggled with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from repeat violence from an intimate partner. They were together over 3 years, and there were several prior incidences of violence. We've got the photographs. There were incidences where police were called who took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. And considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statement. And then you're going to hear another side. And you're going to have to weigh that, all the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. Now let's talk about this day, February 23rd of 2020, the date of this event. This case has been pending for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon And they come out with one of those larger bottles of the wine. And then, of course, there's a receipt. And the bottles are in the garbage can. Of course, there obviously is an attraction between the two. And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes of disagreement. And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah. And you're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad, moody, and a lot of times eventually it involved forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card, and he went over to the Publix and he got another bottle. I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in and going out, and there'll be a receipt for the purchase of that bottle, and then they'll keep that bottle. Will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows this is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle. Well, she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. Malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it. And that's how they hold it back and forth. Well, she comes down the steps. She sees him getting in and settling in the suitcase. So she walks over there, and they see each other. They smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch. And at some point, he says, I can't breathe. Now, his face is facing the zipper, and she's She's got 2 or 3 inches that she's opened it. And she doesn't know, they're intoxicated, she doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen. It's a unique form of physical restraint. And so she lets him have it. Says things she shouldn't say. You'll see the video. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George's, the suitcase is flipped upside down. The zipper's on the bottom. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, Sarah. And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened. She will explain why it happened. The evidence will show that she was justified in the action she took to prevent an attack from Jorge Torres, which the law acknowledges that every one of us has a right to invoke, the right of self-defense. You can hear from the medical examiner. She is going to tell you about some bruising on Jorge Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you. Why that happened. What were the circumstances surrounding that? Involving that. Her son comes and stays with him from time to time. He has his own room. He has several of his things there. And there's a bat downstairs. The same bat that Jorge Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate. Sarah loved you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggles. Sarah had no intent to kill him. The prosecutor mentioned she wanted him to die. Farthest from the truth, she loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, as many of us do when we drink too much, you know, you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees the suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband, really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. Where her son is at? Lucas. It's the only thing she knows to do. She was kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. She called 911. She calls 911 within a minute, 2. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, you know, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these 2 videos. Sarah's not aware. She doesn't remember making the video. You can imagine. She gives them the phone. Well, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, They end up having a conversation with the female detective, homicide detective, Hobson is her name, Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant. They said, end up, hey, we're not gonna bring your phone, I'm not feeling good, pregnant, can you come to the sheriff's department? Which Sarah Boone was to tell you, that was what I was going, that's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up already. And they were gonna confront her and try to get her to confess based on the 2 videotapes. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon. When she got there to get her phone, they said, well, we got to come up here. We need to talk. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't, I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking the stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating a witness's credibility.
I'm sorry, you guys. I do have to pause for fair use commentary. Owens saying that Sarah Boone will be testifying probably next week. Well, it's not going to be this week, sir. It's freaking Friday. Jackass. All right, here we go.
And they'll talk about cooperative evidence, other evidence that's consistent with the testimony that Sarah Boone did. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involved the police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are there. So her attitude is not one of distress. We're here today, full packed courtroom. Judge Creighton's here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is You as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in opening or in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Thank you, sir. Can the parties approach for a moment?
Okay. I agree with some of the things he said in his opening statement, which is that Sarah does, in this moment, as far as the jury is concerned, have the presumption of innocence. That's correct. However, I strongly disagree with finding her not guilty because it's the right thing to do. In fact, I would argue it's the most wrongity thing to do since Sarah Boone played the most wrong game of hide and seek ever. Okay. That being said, a lot of people want to know why it is that Sarah is charged with second-degree murder rather than first-degree murder. The reason I believe they charged Sarah with second-degree murder is because a suitcase is not something that one would traditionally think of as a weapon in the way that it was used. Okay, she didn't use the suitcase to hit him. She zipped the suitcase. In order to prove first-degree murder, one of the necessary elements is that
State, you may call your first witness.
the person who committed the act of first-degree murder with deliberation and or forethought could have reasonably expected their actions would result in the other party's death. And we don't have that in this case, which is why I believe that she was charged correctly with second-degree murder. All right, let's get right back into it. I'm sorry for the brief pause. I'm my bad about who they called. I'm going to rewind it a couple of seconds so that we can hear who they called.
State, you may call your first witness.
State will call Juan Torres.
just briefly, I'd like to let you guys know what you can expect. They've called Juan Torres to the stand. That is George's brother, or one of George's brothers, I should say. He has another brother. I think he has a couple of brothers. Anyway, that's not the point. We're going to listen. I'll be streaming the entire morning session of the court today. When they go to lunch, we will take an hour break with them. I will have another stream scheduled for the afternoon. I'm going to stream all day today. Okay, so we hope y'all stay here and stick it out with me. Here we go. Mr. Cacciatore, it appears, will do the questioning for the state. Oh, Mel, I just love you, babe. I'm having a good day today so far. In 5 minutes, I could say something profoundly ridiculous, which will make
Sir, good
you
morning. You can be
rethink
seated.
that statement.
And once seated, if you'd state and spell your name for the record for us, please.
Juan Torres, Juantorres.
Thank you, sir. You may inquire, Mr. Cacciatore.
Good morning, sir.
Good morning.
Can you tell us how it is that you know George Torres?
He's my older brother.
And how many siblings do you have?
6 or 7.
And how long has your family resided here in the Central Florida area?
20 plus years.
And before residing in the Central Florida area, were you guys in Philadelphia, Pennsylvania?
Yes, sir. In Massachusetts.
Your brother, how often, your brother George, that is, how often would you talk with him?
Often we talk, I'd say, on a weekly basis.
And how far away did you live from George?
About 5-10 minutes. Very close.
Would you see him pretty often?
I would try not to go there too much.
Who was George living with at the time that he passed away?
Wait, Sarah.
And without getting into many details, what was your relationship like with Sarah?
We didn't really have a relationship.
Would it be fair to say you didn't get along with her?
Yes.
Back on February 23rd, 2020, did you have an occasion to talk to your brother on that day?
Yes, sir.
And when you spoke with your brother on that day, did you FaceTime with him or did you speak with him over the phone?
We talked on the phone.
Was that phone to your ear or was that phone?
It was on speaker.
And who was present?
My wife and my 2 kids.
And without telling us anything that George may have said to you, can you tell us what the topic of that conversation was?
We were just talking like we normally did. He just calling me to check on me, basically.
Now, in the background of that conversation on the evening of February 23rd, 2020, what did you hear?
Sarah's in the background yelling.
And you recognized her voice?
Yes.
What was she yelling about?
something about choking or how he choked, or I really don't. That pretty much, that was it.
About how long was this conversation that you had?
Maybe 10 minutes, I think it was.
How did the conversation end?
Because she was yelling in the background, so that was it. We just,
Did she sound upset?
she sounded upset.
Did you talk to your brother after that conversation?
No, that was the last conversation I had.
Have you ever spoken to Sarah since that conversation?
No.
I have no further questions.
Any cross-examination?
I have to pause you guys every so often for commentary under fair use. I just wanted to say that it's important to keep in mind, although there's a reason that Mr. Cacciatore kept the direct examination brief. The reason that he kept it brief is because that limits the questions that the defense can ask on cross-examination. So that's why they keep it. That's why they will keep it brief with some witnesses. I mean, what did y'all do? Draw straws just now at the table, deciding who was going to ask the questions? Come on, get it together.
In the beginning, when you started, it was hard for me to hear, but I know you were talking about other siblings, other family members that you had here. Could you repeat that for me, please?
Here in Orlando, I have one sister and 3 brothers.
Sister and 3 brothers?
Yes, sir.
Okay. Now, did your brother George Torres, did he ever stay with you at any time?
No,
Would he ever live with you or any of, I mean, not you, but any of your other siblings?
no.
All right, sir, let's go back to this phone call that you were talking about that was on February 23rd of 2020. And that phone call was approximately 7:30. Is that correct?
Yes, sir.
And who called who?
He called me.
And then y'all were talking. Is that correct?
Yes, sir.
All right. And when he called you, did you notice anything about his speech or his voice?
No, he was fine.
Sounded normal?
Yes, sir.
Okay. So he wasn't slurring his words or anything like that?
No.
By the way he talked or what he talked to you about, could you tell at that time if he had been consuming alcohol?
No, because I knew when he would drink.
Okay. So in your opinion at that time, based on what you heard and what he was talking about, you do not believe he had been drinking alcohol?
No.
Now, you said you heard Sarah.
Yes, sir.
Is that correct? How did you know it was Sarah?
I can tell in her voice.
You recognized her voice. So you could hear her. Is that correct?
Yes.
All right. And you've heard Sarah speak before that time. Is that correct?
Yes.
And you've heard her speak on the phone before that time. Is that correct?
Yes.
And you said that Sarah was yelling. Is that correct, sir?
Yes, sir.
And she was yelling about, he's choking me. Or tell him about choking me.
Yes.
Okay. During that conversation, and you heard her say that, did you ask your brother, what is she talking about?
No, I did not.
Did that statement at that time, did that statement surprise you?
Not really.
You've heard it before?
No.
Based on Sarah's voice that you've heard, was it any indication to you that she had been drinking?
No.
No? Sir, at some point, your brother said he had to go, is that correct?
Yes, sir.
And did he hang up on the conversation?
Yes.
And did he say bye and you say bye?
Yes.
Thank you, sir. I don't have, if I can confirm.
You may, sir.
Here goes Mr. Owens interrupting again.
Sir, other than siblings, your mother and father, do they live in this area?
Yes.
Were there times that George would stay with them?
Yes, sir.
Nightbot and I feel
No further questions.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Defense?
Actually, we'll keep him subject to recall, Your Honor.
Okay.
I would agree with that.
All right, sir. You're released subject to recall by either party. Thank you.
MK, I just want you to know that Nightbot and I have conferred and we've decided it's time for all the people to know what a national treasure you are.
State would call Devin Jamro.
I have no idea who Devin Jamro is, just based on the name. I think it's quite possible that seeing him or hearing him, I'll know. I think he might be the 911 operator. Aw, thank you, Karen. I appreciate that, babe. Okay, no, I'm not sure who this is. It's not the 911 operator. I'm not exactly sure who this is.
Sir, good morning. You could take a seat and please state and spell your name for the record.
My name is Devin Jamro. That's DEVINJAMRO.
Thank you. You may inquire, sir.
Sir, who do you work for?
I work for Public Supermarkets.
And what is your position with public supermarkets?
I am the assistant store manager.
And at what location?
Publix employee.
Currently the Castleberry location.
Were you at the location on Goldenrod and University Boulevard back in February of 2020?
Yes, I was.
Your Honor, may I approach the witness which has been previously marked for identification as states D and been shown to defense?
D is in Delta?
D is in Delta.
Yes, you may.
Oh, yay. Thank you, Toe Beans. I'm so glad you guys are going to be here. This has been a long time coming. I appreciate y'all. Thank you so much.
Could you use these scissors and open this and look at the contents of this package to yourself?
Sure.
How jelly do you think Sarah is that he gets to use the scissors? You know, she loves arts and crafts, and you can't have arts and crafts without scissors, y'all.
Sir, do you recognize those items?
I do. Yes.
And tell us, what are these items?
These are Publix receipts.
Are these receipts evidence of transactions at Publix? Are they made at or near the time of each transaction?
They are absolutely made at the time of the transaction.
And is it in the normal course of business that Publix keeps these receipts?
Yes.
And these fairly and accurately appear to be the receipts from your Publix store?
Yep.
Your Honor, this time I'd like to move what's previously been marked for identification as states D into evidence.
Any objections?
No objection?
What
We
was
love
pre-marked as
receipts.
States D will be received into evidence without objection as States 1.
And yes, I am happy to see Mr. Cacciatore doing some of the questioning, but we love receipts here at the Ward Case Studies. Literal receipts.
Your Honor, may I approach the witness who's been previously marked for identification as states J and shown to defense?
You may.
Understatement of the year, Mel, whatever.
Sir,
Actual
showing you has been marked for
receipts.
identification as states J. Can you take a look at that disc?
Yes.
Do you see your initials on that disc?
I do.
Did you have an opportunity to look at that disc prior to coming to court this morning?
I did. Yes.
And tell us, what is that disc?
This is CCTV footage burned from the camera system at the location.
And at Publix, is it the regular practice of Publix to utilize surveillance cameras?
Yes.
And in the normal course of business, are the videos from those surveillance cameras kept?
Yes.
And are these the cameras taken from February 23rd, 2020? And I believe there's 2 video clips included, one at 12:17 p.m. and another at approximately 5:39 p.m.
Yes.
And they fairly and accurately represent the surveillance video that was submitted from Publix to law enforcement in this case.
They do. Yes.
Your Honor, at this time, I'd like to move what's previously been marked for identification as states J into evidence.
Any objections?
No objection.
What was pre-marked as States J will be received into evidence without objection as States.
Just real quick, I'd like to submit this quick Google search that I did respective to the Woodbridge Buttery Chardonnay at the 1.5 liter as Exhibit A into evidence. The alcohol content is 13.5%. That is the same brand and size of the bottle that was purchased at the Publix. I'd like to mark this again as the Ward Case Studies Exhibit A. I believe it would be admitted into evidence without objection. Here we go. Let me hide this really quick. Sorry, you guys.
States 2.
And I have no further questions for this witness.
Any cross-examination?
Yes.
Can this witness be released?
Yes.
Thank you, sir. You're released.
Thank you.
Have a great day. State, you may call your next witness.
State would call Joan Williams.
The ward would like to instruct Mr. Owens to take his seat. Yes, Carolina, I mean, it does have a substantial alcohol content, especially if you don't eat.
Ma'am, good morning. Could you state and spell your name for the record for us?
Whoa.
Joan, Joan Williams, Williams.
Thank you, ma'am. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
Can you tell us what it is that you do for a living?
I'm a 911 call taker at the Orange County Sheriff's Office,
And how long have you held that position?
24 years.
And tell us, what are your duties as a 911 call taker?
I answer phones for an emergency, non-emergency, medical, which I transfer to the medical side of the business.
And is it the regular practice of Orange County to record 911 calls?
All lines are recorded.
And is it the regular practice of Orange County to keep records of each of those 911 calls?
Yes.
And those records are made at or near the time of each call, correct?
Yes.
Your Honor, may I approach the witness which has been previously marked for identification as states L and been shown to defense?
You may.
No, Michelle, just that
I'm showing you what's been
hold on.
previously marked for identification as states.
they called the manager from the Publix because they needed him to identify some evidence. One is the closed circuit TV footage, and two were the actual receipts for the wine purchases. That's what his job was there for. I suspect later they will actually publish those receipts and publish that closed caption TV footage. They just needed him to verify that that is indeed what it was.
L. Do you recognize this disc?
Yes. My initials.
Did you have an opportunity to review this disc prior to coming to court this morning?
Yes.
And those are your initials on the disc?
Yes.
And does this disc, does it fairly and accurately represent the 911 call that you took in this case on February 24th, 2020 at 12:59 hours?
Yes.
Your Honor,
Yes,
at this time, I'd
Melissa.
like to move what's previously been marked for identification as states L into evidence.
Any objections?
No objection.
It was pre-marked as states L will be received with no objection as states 3.
Yes, I think that's the suitcase.
Your Honor, I
do.
have no further questions.
Any cross-examination?
No, sir.
Can this witness be released?
Yes, Your Honor.
Thank you, ma'am. Can the parties approach momentarily?
If you're talking about this right here, yes, I do believe that that is the suitcase. And now that it's noon, Florida time, I would imagine they're about to discuss lunch. Should that be the case, and they end, or they, take a break, they are in recess for lunch. Usually it's an hour. So then what I will do is also end the stream and schedule the next stream for 1 hour from now. Just be sure that you have notifications set to all, because sometimes notifications, when you do that, they don't go out that great. So just, know that if we end for lunch, I will be back in 1 hour. Let me see if I can. We're a little bit behind, so. Oh, too much.
Raise your right hand, be sworn. Please be swear or affirm that the testimony you give
Sir, you may be seated. After you're seated, if you can state and spell your name for the record for us.
Vincent Battaglia, Vincent Battaglia.
Thank you.
Okay, if you guys don't remember, this is Vinny. This is the neighbor of Sarah Boone's who shared the wall. They had that shared wall, who told homicide detectives when he was interviewed that he heard them fighting all the time, arguing all the time, but more importantly, he heard something fall down those stairs that shook the wall, that bounced between the wall and the stair railing. That's who this is.
Sir, you may inquire.
Good morning, sir.
Morning.
Can you tell us what it is you do for a living?
Right now I work for an auto parts company,
And where do you live?
New Jersey.
Back on February of 2020, where were you living at that time?
I was living at the Tealwood Apartments in Winter Park, Florida.
And what were you doing at that time when you were living at Tealwood?
I was enrolled in Full Sail University. I was in school.
When you were living at Tealwood, did you have any roommates?
Yeah, I had one roommate, Brandon. Yeah, that was it. Him.
That's Brandon Motes?
Yes.
Did you have neighbors?
Yeah.
Were you neighbors with Sarah Boone and George Torres?
Yes.
And approximately how long were you neighbors with them?
About a year, a little over a year. I moved there in January 2019.
And during the course of that year that you were neighbors with them, did you have occasion to interact with them at times?
Yeah.
In fact, did you ever go over to their home?
Yeah, like a couple times, yeah.
And I believe you tuned a guitar for a child there at the house?
Yeah.
This Tealwood apartment complex, how would you describe the walls that separated your units?
Thin, like very thin walls.
And with those walls being so thin, would you ever have occasion to hear arguing and yelling coming from Sarah Boone and George Torres's apartment?
Yeah.
How often would you hear this?
Almost daily.
Did Sarah Boone ever approach you about the things that you heard coming from their apartment?
Yes.
And where were you when she approached you?
I was smoking a cigarette on my back patio.
And approximately what time
It was
was this?
pretty late. I can't remember the exact time, but it was definitely anywhere between like midnight to 2 a.m., like right around there.
And do you remember how much before the date when the police called that this occurred?
A few months, like it probably 4 to 5 months before that.
So 4 or 5 months before February of
2020.
2020.
Yeah.
And when she approached you on this late evening / early morning on that day, what did she tell you?
Pretty much just kind of like if I do hear anything like through the walls or whatever is out back, just kind of keep my mouth shut. Like don't really speak about it or anything like that or say anything to anyone. And I just was like, okay.
Did she make any motions with her hands?
Yeah, like just kind of like, you know, finger over the lips, like kind of shh, like keep it hush, like that kind of thing.
So she told you not to report anything you may have heard about arguments or yelling or fighting, anything going on over there?
Yeah.
Do you recall the evening of February 23rd, 2020.
I do, yeah.
And what about that evening sticks out to you?
That sticks out to me from that night was literally just there was a very, very loud noise that I heard that was loud and powerful enough to shake my bedroom wall. And I remember that because I was sitting on my bed on FaceTime with my girlfriend at the time, and I literally felt the wall shake and it stopped me mid conversation. And she even asked me through the computer, like, what was that? And I was like, I have no idea.
Did you hear any yelling coming from their apartment on that night?
Before that, yeah, like it was just arguing kind of stuff.
What was the last thing you heard?
The last thing I heard was like the loud noise and just a little bit of shuffling, and that was kind of it. It just kind of went silent after that.
Could you hear anything that was being said?
Not clearly, and it was never really anything clear. It was just like you could hear arguing back and forth, just kind of like and kind of like an I hate you, like it's whatever it is, whatever the argument was about kind of thing. At the time, that's really all it was, but it was never really clear enough to hear like the full argument. And honestly, I never really paid attention too much to it. If I heard it, I kind of stepped into my living room to be further away from it.
Did you hear both the defendant's voice and also George Torres's voice?
Yeah, all the time. It was like a back and forth.
So other than the statements and the phrases of I hate you, you weren't able to discern the contents of this argument.
No.
What was the last sound you heard?
The last sound that I heard was like the loud banging noise that it was like a very odd sounding noise that I've never heard before this day, but it very much sounded like it was where my bed was positioned. It was kind of towards the back of the apartment, and it almost sounded like it was coming towards me, but like on the side of me, then it was just like a loud rumbling noise. That literally sounded like it was kind of far away from me, and then it like ended up like almost next to me. And like I said, the walls are thin, so like it's very easy to hear like through the walls, and not even just sideways. Like I hear my upstairs neighbor, like all around, very thin walls.
Now, was your bedroom, where was it located in your apartment?
The back of the apartment, so it was like there's like a little kick out next to my patio, and that's like that was my bedroom back there, like along the grass back there.
On the first floor?
On the first floor, yeah.
I have no further questions.
Any cross-examination?
Mr. Tagley, good morning.
Good morning.
Now, you said that you lived there next to Sarah Boone and George Torres for about a year.
Yes, sir.
Are you aware that the police were called to their residence
Like,
while you were there for the year? Are you aware of any incident in which the police were called to their residence?
I had never seen anybody there, but I had had other neighbors in the complex tell me that it has been on multiple occasions. So that's why.
Just instead of what somebody else told you,
Yeah.
just what you would observe. Did you ever, the year that you were there living next to them?
Yeah.
Were you ever aware that the police were called to their residence?
No, the times that I was home, I never saw any police at the apartment there.
And did you work odd hours or you went?
Yeah, and with my schooling and stuff too, I used to have class at like 1 o'clock in the morning. So all the time I was at random moments, like just not home throughout the day and night and stuff like that. So yeah.
Do you have an opinion as to whether or not, based on your interaction with Sarah Boone?
I'm going to object.
Let me finish the question first, please.
Do you know from your experience with Sarah Boone and your experience with George Torres that they drank alcohol?
Yeah.
Hang on.
I'll withdraw to that question.
Okay, thank you.
Yes.
Are you aware that they both consumed alcohol to excess?
Yes.
Thank you. Hold on.
Yes, sir, of course.
Vincent, I think you had testified, you may have given a statement to law enforcement,
Yes, it was one of the detectives.
a recorded statement.
Yes, I can't remember his name, but yes.
Okay, and I think it was on February 23rd of 2020.
Yeah, right around that time. Yeah.
I believe you had said that,
I'm going to object as to improper impeachment.
Approach. Objection's overruled for now.
sir, would it be fair to say on that date you got home around 7 p.m.?
7 p.m.
Yes.
Which day was this?
Sunday, February 23rd, 2020.
No, that day I actually got home from work probably around 1 or 2 o'clock or so.
In the morning?
No, in the afternoon, because I went to work that morning at around 5 a.m.
And you said that you heard the normal yelling and arguing at about that time when you got home?
No, it was around that time, but it was really around like 10 o'clock, 10:30 is when like the arguing I could really hear clearly. It was like around 10:30 at night.
Okay. Thank you. Thank you.
Any redirect?
Just very briefly.
Yes, sir.
So on cross-examination, you were asked about the arguing you heard, and I believe your testimony was that it was pretty intense around 10:30.
Yeah.
Approximately what time was it that you heard this loud crashing thump sound that you described?
Little after that.
Overruled.
It was a little after that arguing and stuff. It was probably around 11:15, probably 30, 45 minutes after like the arguing I could hear started.
No other questions?
Can this witness be released?
Yes, John.
Not subject to recall.
We would like him subject to recall. You've got his number.
Okay.
Your Honor, may we approach?
Yes.
Okay. So if I had to guess, probably the reason that they are wanting to approach is because if you, at the beginning of his testimony, Vincent said, excuse me, that he lived in New Jersey. Now, when a witness is under subpoena by the state pays for them to be here. They also have to put them up, meaning providing lodging. Okay. And by the state, I mean the taxpayers of Florida. So if
All right, sir. You are released, not subject to recall. Have a great day. Thank you.
So, excuse me, Your Honor, if the defense wants them to stay and be subject to recall, they're the ones that are going to have to foot the bill, which is why I suspect they just released him from the subpoena.
The state would call Brandon Moats.
Okay, so just give me 1 second.
Bless you.
Excuse me. Brandon Moats is the neighbor. Also, he was Vinny's roommate. Now, I'm quite interested in this because, as you know, Mr. Owens made an argument either at the end of September or the beginning of November. I just skipped I just completely erased October from existence. It was either at the end of September or the beginning of October. I cannot remember which motions hearing it was, but he was quite frustrated because he couldn't locate the neighbor. And lo and behold, the state has them as witnesses. So this is quite curious to me. This is Brandon. This is Vinny's roommate. These are the two neighbors that told detectives that they heard that loud bang come down the stairs.
Thank you, sir. You can be seated.
Where
State and
Free
spell your
Dragon
name for the
came
record,
from.
please.
Yeah, my name is Brandon Moats, BrandonMoats.
Thank you. Mr. Cacciatore, you may inquire.
Good afternoon, sir.
Good afternoon.
Can you tell us how it is that you knew Sarah Boone?
I moved into the apartment next door to her when I was in college.
And so when was that you were in college?
I would have moved down here in 2019 and would have been there until like 2021, 2022.
So she was your neighbor at Tealwood Apartments, is that correct?
Yeah, it would have been Tealwood back then, yeah.
And did you have any roommates back then?
Yes, I was rooming with Vincent Battaglia.
And during that time, what were you doing?
Like,
as far as work and school? And
I was just going to school. During the time of this, yeah, I would have just been going to school. I don't think I would have had my job yet. I was just a student.
Did you have much interaction with the defendant or with Jorge Torres in this case?
Honestly, I avoided them as much as possible usually.
The apartment where you lived, tell us, how would you describe the walls that separated the units?
Yeah, I remember that my bedroom was like the front facing bedroom and our walls shared a wall with where their staircase was. So like the way the apartments were laid out, we had a 1-story apartment, they had a 2-story apartment. So they had a staircase running right next to the walls next to like our bedrooms.
Would you ever have occasion to hear arguing and yelling going on inside of the defendant's apartment?
Yes, the walls were pretty thin. So if people were yelling, you could definitely hear it.
And how often would you hear arguments or disagreements going on over there?
When I first moved in, it was it was at least like once a week, to the point that I started tuning them out. Like I got good enough at just like not listening to them. They argued very, very often.
Do you recall the evening of February 23rd, 2020?
Yes, sir.
And on that evening, could you hear arguing going on in their unit?
Not late into the evening, earlier into the evening, probably like 7, 8 o'clock that evening, probably like earlier on, I could hear arguing.
And where were you inside of your apartment?
I would have been in my bedroom pretty much all night.
And your bedroom, just so that we can paint the picture, where would that would have been, on the first floor or the second floor?
We had a first floor apartment.
Okay, so all the units were, or all the bedrooms were on the first floor.
Yeah, like I was saying before, we had a 1-story apartment, and then they next door had like a 2-story townhouse. So we only had the 1 floor.
Understood. And at a certain point in the evening, did you hear a loud crashing sound?
Yeah, probably around 10:30, 11 o'clock that evening.
And can you describe that sound for us in more detail?
I mean, yeah, at literally, like I said, at like 10:30, 11 o'clock, it's the way their staircase was set up. I could, my bedroom, the top of their staircase would have been like above my ceiling. And it ends next to where like my roommate's apartment was. So I could hear something start above me super loud and then fall away from me like it was falling down the stairs.
And there it is.
Did this affect the walls that were between your two apartments?
Oh yeah, me and my roommate, I remember me and my roommate talking the next day about like we could literally like it shook both of our rooms.
Did you ever have occasion to talk with the defendant about what happened?
I never saw her after that. She would have, yeah, I never saw her after that happened.
No further questions.
Any cross-examination?
All I keep thinking about, hold on, I got to pause for
Good
a little
afternoon, sir.
commentary. Excuse me, sir. I got to pause for a little commentary, but I'm reading in the chat and all I can think of is, whoop, there it is. Whoop, there it is. Shaka laka, shaka laka, shaka laka, shaka, whoop. That's all I can hear in my brain right now.
Good afternoon.
Sir, you were asked by the state if you ever had any interactions with Sarah Boone or Jorge Torres. Is that correct?
Yes, sir.
And I think you said you tried to avoid them.
Yeah, I don't like drunk people, and they were drunk a lot, so I did not interact with them.
Okay. Do you remember this interaction with Sarah Boone in 2009 when you woke up and witnessed Sarah?
I would have been 9 years old in 2009.
I'm sorry, 2019. Good catch. In 2019, when you woke up and witnessed Sarah sleeping on the concrete patio.
Oh, this may have been a slight misconception in how I said this. I never woke up and saw her sitting on the patio myself. That I would have seen her on the patio eventually, but it's not like I woke up and went back and saw her on the patio. This was my roommate relaying the story that she had fallen asleep on the back patio, and then I like saw her.
Okay. So you did not witness that yourself, or did you see her?
I saw her asleep on the back patio. I was just clearing up the sequence of events there.
Okay, thank you. Another time, do you recall our interaction with Miss Boone when you were coming home from school and she was trying to talk to you and she seemed paranoid and rambling?
Yeah, I had gotten locked out of my apartment, so I was waiting on the steps waiting on the steps outside of my apartment for my roommate to get home. So she came up and started talking to me. I don't really remember too many like details of what she was saying, because I didn't want to talk to her. But yeah.
Okay. Do you remember saying that you believe Sarah was avoiding going into her apartment?
That's definitely the vibe. I don't remember what she was saying, but like the vibe she was giving off was that she didn't want to go home.
I believe, and I just want to make sure that I heard you. You said that the first arguments, other than the Boom, which was like 10 something, initially it was around 7 p.m. You heard arguing?
It would have, yeah, because it would have been. I remember that day I got home from class around 5, because because I got out of class around 4:30 usually and walked home. So I would have gotten home around 5:30. And it would have been after I took, because I came home, I made myself lunch and I took a shower, and then I heard all of their arguing. So it would have been about an hour and a half, 2 hours after I got home. So around 7 to 8 o'clock.
Okay. And during that time, when you say arguing, was it back and forth?
I honestly, I wouldn't really be able to say if it was back and forth. I don't know I wouldn't remember too vividly if it was back and forth. Or if it was
Let me
just
ask you
one
this.
person
Did you
yelling.
hear a male voice?
Yes, I heard a male voice.
Did you hear a female voice?
Yes.
Okay. Were they both loud?
Yes.
Oh, thank you so much, Bonnie. I appreciate that.
Yes, sir, of course.
I really do. I appreciate that. Why do you need to converse with Mr. Owens? You listened to his testimony. You're listening to it now. What do you need to ask? I don't understand this. Let's get this show on the road.
Thank
Come
you, sir. I
on,
have no
bro.
further questions.
Any redirect?
All that for
No, Your Honor.
This
nothing.
witness be released.
Yes, Your Honor.
Subject to recall, Judge.
All right. All right, sir, you're released, subject to recall. Thank you. Can the parties approach?
I believe now we will be discussing lunch because it's 12:25 p.m. currently in Florida. This so far is, they're testifying exactly the way they stated in their interviews with police. They said it pretty much almost verbatim, really, what, hold on a second. They're testifying almost verbatim to what they said in their interviews, both Vinny and Brandon. And I can't shake my confusion with Mr. Owens over this can't locate the neighbor, because here they are. State didn't have a problem. One of them doesn't even live in the state of Florida anymore. Huh. I'm hungry too. But I'm worried that if I eat lunch, it's going to make me sleepy. And I'm worried that I will be sleepy for the rest of the trial. Oh, Jojo. Yes. Okay. So Jojo says, I asked earlier and don't think anyone saw it, but do they get to watch her video from that night? Yes, they do. It will be admitted into evidence. The jury will get to watch it. They address the video, both sides did, the defense and the state, in their opening statements, and they both mentioned the video. I will say that Mr. Owens has a slightly different view on that video and what it actually shows, because he said something to the effect of that the videos are 11 minutes apart. It's what happened in those 11 minutes that is the key to this case. That is how he views the suitcase video, as it has been named. Our urban homestead, what you missed is the two neighbors. If you recall, Vinny and Brandon, they lived next door to Sarah Boone. They had a one-story apartment. Their bedroom walls were a shared wall with Sarah, with her townhome.
Members of our jury, thank you so much for your time, your attention, and your participation in this very important process. It is 12:21. At this point in time, we're going to go ahead and take our lunch break. I'm going to ask that you return here no later than 2 p.m. so we can pick up at that point in time outside of here, 12 Alpha in the Orange County Courthouse. And I'm going to give you an instruction. You're going to hear this instruction a lot over the...
Okay, 2 o'clock. All right. So they're the ones that had the shared wall, and they're the ones that that told detectives that they heard somewhere between 10:30 and 11. So it sounded like something falling, and it was so loud that it shook their walls. And that is what they told detectives, and that is essentially what they testified to here today. So, in my opinion, of the witnesses that we've heard from so far, those would probably be the two most important witnesses. The first witness was Juan Torres. He is George Torres's younger brother. He testified that on February 23rd, George called him and they had a conversation. And in the background, he could hear Sarah yelling something to the effect of, "Tell your brother you choked me," something like that. He said he wasn't really shocked to hear that, but it was also the first time that he'd heard that, which I thought was interesting. That he'd never heard that George had choked Sarah before. So that is what we heard. We also had the 911 dispatch, the first voice you hear on the 911 call, the female voice. She testified and basically authenticated the recording of the 911 call. It was not played. The other witness that was before her after Juan was the assistant manager at the Publix, where George and Sarah frequented. And on that day, George purchased the wine, and he was able to authenticate the two Publix receipts and the closed circuit TV video that from inside the Publix store. And that was the extent of his testimony. He was really there to authenticate receipts and the video. So that's about it. It looks like they're headed to lunch. Let me just see if there's any business that they have to take care of in between before they they break for recess, and before I end this live, so you guys don't miss anything. And I don't miss anything. All right, here we go.
The next couple of days, jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home.
We don't need to hear this. We know that this is just standard instructions, but I do want to say thank you, our Urban Homestead, who says, "Thanks for the recap, Bendy. Looking forward to your afternoon sesh. Love your snark and commentary." Thank you so much. Victoria says, "Thanks for streaming this, Jen Lou. I love your commentary." Thank you. Thank you so much. I appreciate that. I'm glad that you guys enjoy the commentary. Some people, they're not a fan of it. It is what it is. Can't please everybody, but you can piss everybody off. I just want to make sure that there's nothing else happening in the courtroom. I don't want to miss anything. So let's turn it up just really quickly.
Information on an internet website, chat room, or blog. With that, members of the jury, please leave your pens and your notepads on each chair. The deputy will collect them. We'll see you at 2 o'clock, and I thank you for your service.
Okay, night-night, Mel. Sleep tight. Don't let the bed bugs bite. Thanks for being here, babe. I think this should be it, but I just want to make sure. You guys know how I am. I don't want to miss any details. Let's see. Yeah, I think we good. All right, you guys. So I'm going to go ahead and end this. If you haven't done so, please give your girl a thumbs up on the stream. I would greatly appreciate it. I am going to schedule the next stream for 2 p.m. Make sure you have your notifications set to all. Also, maybe just go actually to the stream once it's set up. Give me like 5 minutes. It should be uploaded. Because sometimes when you do streams this way, YouTube doesn't always send out the notifications, and I don't want to miss any of y'all's little faces for the afternoon session. All right. Thank you guys so much. Have a great rest of your afternoon, and I will see you at 2 o'clock Eastern. Thanks, y'all. Bye.